Kuna participants hour, kuna judges pale na audience. You can capture all of them. Sio, unaweza capture wote.
Unajua ukishika rekodi hapa tu ndo bora mpata kupata profile. Simba hii ni court. Si harusi. Kwa sababu ni nini kitu yote na kama. Ajili ni mtaki. Kwa kibongo unaweza kupata. Wale kibongo unaweza kupata. Unaweza tani hivi. Unaweza nyongeana hivi. Sio hilo. Hao ndio wametuleta hapa na ni ndogo. Wakipanga hii kitu hapo wanajua tutafuta.
Because I'm the one who's underlying these things that you want to reframe. This is mine.
Excuse me, please. Our judges will be arriving in the next 2 minutes. Excuse me, silence. Our judges will be arriving in the next 2 minutes, so I kindly request that once they are coming in, we all be at standby. Thank you.
I'm going with this
Mic check 1 2 1 2.
All right.
of striking the balance between the respect of human rights and maintaining national security. I invite the judge to continue.
Good afternoon. The court is in session. On behalf of the bench, we would like to welcome counsels for the applicants, petitioners, and counsels for the respondent. I would like and invite my colleagues to introduce themselves from my extreme left to right.
Victor.
Irene Ikomu.
Roseland Mutoka.
James Kironji.
And I, Muhavi Mugambi, presiding. For the first counsel for the petitioner, please address the court.
Good morning, good afternoon, Your Excellencies. My name is Kadima Cedric. I'm the lead counsel for the petitioner, the matter being the Nadia National Human Rights Commission, in this regard, the Commission versus the State of Nadia. With me is my co-counsel, Ms. Nafula Masinde. Together we are going to demonstrate that to demonstrate before this court on issue number 1 of the merits, number 2, and number 3, that it should be admitted and thus the orders that we will seek be granted. Your Honor, personally, I shall take 16 minutes of the court's time to demonstrate that issue number 1 for determination has merit. My co-counsel, Ms. Nafula Masinde, will take 14 minutes, Honor, will take 13 minutes of the court's time to demonstrate that issue number 2 and 3 has merit and thus be admissible and the prayers be granted. Your Honor, with the permission of the court, we shall spare 1 minute for rebuttals. I beg to proceed. Your Honor, shall I address this court on the preliminary issues or it should be read from our substantive submissions?
Counsel, please proceed to your substantive issue.
Thank you, Your Honor. Your Honor, I have stated before and on several times that milk and honey are of different colors, though they exist in the same house peacefully. The matter arising out of issue number 1 is a matter of national security vis-a-vis human rights. And Your Honor, the petitioner submits this afternoon before this court that the actions by Nadian state actors to quell the demonstrations was in violation of the Nadian Constitution and international human rights instruments which they have ratified. Your Honor, the main right is the Article 37 right of the Constitution of Nadia, the right to assemble, the right to picket, to public authorities and to present petitions, Your Honor. And Your Honor, as was stated by the High Court in 2016 in the case of Ferdinand Waititu Ndung'u versus the Attorney General and 12 others, it noted that the right under Article 37 is a precious right. The right provides an alternative form for persons to participate in democracy. And Your Honor, from the statement of facts, 4PC and Kituo are advocating for electoral reforms. They are protesting against extrajudicial killings of the police. And therefore, they deserve the protection of that right. We as the petitioners do recognize that Article 37 has a caveat that demonstrations must be peaceful and that the demonstrators must be unarmed for them to enjoy that right, as was the position of the Court of Appeal in the case of Hussein Khalid and 16 others versus the Attorney General and 2 others. However, this court should also take note that the same Court of Appeal in the case of Hussein noted that demonstrations in some way always results to violence. And in regard to that, the police must exercise some restraint. The police must exercise some caution when dealing with demonstrators. And therefore, they should show tolerance, not to disperse the demonstrations because 1 or 2 or some of the demonstrators are armed or some of them show violent conduct. Therefore, what is the obligation of the police when these demonstrations are in some way turn violent or some demonstrators are armed? The obligation of the police, as was stated by the High Court in the case of Ferdinand Waititu Ndumu, which I've stated before, and the decision was affirmed by the Court of Appeal, the police are required to isolate, they are required to arrest all those persons demonstrating unlawful conduct during demonstrations. But have the police in Nadia done that? No, Your Honor. They have instead dispersed the demonstrators. Your Honor, we know the respondents will rely that due to the past history that the demonstrations always resulted to violence. But the question before this court, where were the police when the demonstrations were resulting to violence? Your Honor, the Court of Appeal affirmed the same decision in Ferdinand Waititu, that the police are supposed to ensure that demonstrations are peaceful by protecting the demonstrators themselves, by protecting the public themselves, Your Honor. But in this regard, the police in Nadia have failed those obligations, Your Honor. And Article 37 right has a twofold obligation to the state. The state has a negative obligation not to interfere with the enjoyment of Article 37 right, and it has a positive obligation to ensure fulfillment of Article 37 right. To support my argument, it was the same decision by the Human Rights Committee in General Number 34 on Article 19 of the ICCPR, which stated these two obligations respecting the right to assemble, demonstrate, and picket. Therefore, did the actions of Nadian state actors to quell the demonstrations in compliance with the negative and positive obligation respecting to Article 37 right, of which as the petitioner, I submit that they did not for the following reasons, Your Honors. First, in regards to the negative obligation, if there is suppression of demonstrations by the actions of the state, for example, through issuing of orders warning demonstrators with no justifiable reasons that they should not attend demonstrations and labeling them as criminals, labeling them as power-hungry individuals, Your Honor, that is a suppression of demonstrations. This was the same position of the African Commission in the case of Gumne and others versus Cameroon. Number two, if the use of force against peaceful demonstrators, then it will be considered a violation of the state's negative obligation. This was the same position in the Supreme Court, in the Court of Appeal, in the case of Hussein Khalil, which I've mentioned before. Your Honor, the police in Nadia, Officer Kilina and his crew, went to a place whereby they suspected that it will be the epicenter of the demonstrations. Instead of monitoring the demonstrations, they waited to disperse the demonstrators. And what did they use, Your Honor? They first threw tear gas at them. They did not stop there. They used water cannons at peaceful demonstrators. As if that was not enough, they took their hand batons and used them against demonstrators, Your Honor. Your Honor, even that did not satisfy them. Actions of Officer Kilina, he cornered Tanjari. Tanjari was an armed protester, protesting against excessive use of force by the police. She was running for her life, but Officer Kilina cornered her, beat her with a hand baton, kicked her with heavy police boots. And you know the nature and way police boots are made, Your Honor.
Counsel.
Yes, Your Honor.
A clarification from the bench. What then do you propose should be the ways in which police can use to disperse armed protesters or rioters? What other methods other than tear gas, water cannons, and hitting them with police batons? What other methods can you propose the police can use?
Your Honor, I'll respond to your questions in two ways.
Add on to that question, what is the place of the Public Order Act that supports the way in which protests are to be conducted, and what is the place of the attire of the police? What does that demonstrate when they wear the protective gear to the protesters?
Thank you, Your Honor. To answer the presiding judge's question, I'll answer it in two ways first before I proceed to the second judge. In the first question, Your Honor, the police first are required to disperse protesters if they turn violent by using non-violent means first. This is by using tear gas, of which as the petitioners we do not contest that, since it is a non-violent means. But if the demonstrations turn violent, does it justify for the police to use live bullets against demonstrators? Your Honor, in the case, Your Honor, the police are supposed to use rubber bullets during demonstrations.
Counsel, how many victims do we have who were shot by the police?
Your Honor, from the facts, first, it is uncertain as to the many number of the demonstrators who were shot, since we are told that some of the demonstrators were shot with live bullets. And secondly,
so
we are informed...
we do not know how many.
Your Honor, for sure, there are many, as the petitioners you can submit. The police know that, Your Honor. Your Honor, I beg to proceed to answering your question. The place of Public Order Act, in the case of Ferdinand Waititu Ndung'u, the same case in the High Court, they went further to state that the Public Order Act does not seek to limit the Article 37 right. Rather, it seeks to regulate public processions and ensure public order. And in that regard, it has several provisions as to how a demonstration can be declared illegal as per Section 510 of the Public Order Act. And Your Honor, the respondents did not give any justification as to whether the demonstrations were illegal. Instead, they went ahead to disperse the protesters with no justification, Your Honor.
Counsel, let me ask you a question.
Yes, Your Honor.
Is Article 37 an absolute right?
No, Your Honor, it is not.
Absolute.
Yes, Your Honor.
Can it be limited as provided for Article 24?
Yes, Your Honor, it can be limited.
What is the duty of the police in terms of guaranteeing the right to protection of property in Article 4?
The duty of the police in ensuring that there is no destruction of property under Article 40, they are supposed to arrest, they are supposed to isolate.
And the police act preemptively in terms of safeguarding other people's right to property?
No, Your Honor, until it happens.
Until it happens?
Yes, Your Honor.
There must be destruction before the police intervenes.
During the breaking into private property, the police can intervene.
Before or after?
In either way, they can intervene before, during, or after.
Now listen, are those rights? Are rights enforced horizontally or vertically or both ways?
Rights are enforced both horizontally and vertically, Your Honor.
So a citizen has a right to protect the right of another citizen?
No, Your Honor. A citizen has no right to protect. The obligation to protect the right of a citizen solely belongs to a state.
You're sure?
Yes, Your Honor.
There is no case in this country that talks about rights.
Your Honor, to support my argument, the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, the African Commission...
Speaking of local jurisprudence.
Your Honor, on local jurisprudence, the same case of Kenya National Human Rights Commission versus the Attorney General and two others, it was the same position.
Okay. Point me to a specific article of the Constitution that says rights are only enforceable horizontally.
Your Honor, there is no specific provision in the Constitution whereby it is stated that rights can be enforced.
So there is no force of law that submission is dependent on?
No, Your Honor. This is dependent on constitutional principles. Your Honor, if I may proceed with my submissions. Your Honor, therefore I submit that the state violated its negative and positive obligation respecting the right to assemble, demonstrate, and picket. And thus, Your Honor, if we were not granted these orders, that the actions of state actors to quell the demonstrations violated the right to assemble, demonstrate, and picket, Your Honor, it will lead to a state whereby citizens can no longer enjoy the right to assemble, demonstrate, and picket on the verge.
Council, on
Yes.
that point, how long have these demonstrations been running?
Your Honor, soon they have been running before the electioneering period.
But they've been running for a number of weeks, these demonstrations.
Yes, Your Honor, they've been running for a number of weeks.
Council, you are also aware that the government spokesperson did put out a statement on how these demonstrations were getting violent.
Yes, Your Honor, I am aware of a report given by the spokesperson of the police, but it's not part of a witness statement before this court, so we cannot ascertain as to the truthfulness of such information.
Council, having said that that is not part of the court records, you have alluded to the fact that many people were shot, isn't it?
Yes, Your
By
Honor.
the police, the respondent state's agents. Do you have any ballistic tests to ascertain that the gunshot wounds from the victims are actually from the guns from the police officers? Or they are also not part of the court records?
Your Honor, I beg for them to be considered as part of the court records, since we are even went
Where are they? Where are they? Can you please produce it to our bailiff so that we can peruse it?
Your Honor, after court session. Your Honor, I was submitting before this court that if we are not granted the prayer that the state violated the right to assemble, demonstrate, and picket, what will be the position of children like Tanjari's brother who are playing in the field and the police went there to shoot like bullets? Your Honor.
If I may ask you a question, I think my sister had alluded to the warning that had been issued by the government that the protests have been happening for some time. And I want you to address me on the 6th schedule of the National Police Service Act on the conditions on use of force, particularly subsection 1 that talks about police using non-violent means, unless the non-violent means will be ineffective or without any promise of achieving the intended results. What's the place of that within this situation?
Your Honor.
Council, respond to that question while you are winding up. You have 2 minutes to wind up, isn't it?
Yes, Your Honor. To answer your question, the position of the 6th schedule of the National Police Service Act, as you have said before this court, the police are supposed to first use non-violent means. If they fail, then they have to resort to violent means. But violent means does not mean the police to shoot live bullets at demonstrators. And as was considered in the case of Lucas Omoto and 2 others versus the Attorney General and another, Your Honor, whereby the police used live bullets to arrest a person, the Court of Appeal gave a criteria that if you are to use force, like use of live bullets, you have to consider if you are pursuing a dangerously armed person, but was Tanjari armed. It gave a second criteria that if you are on a hazardous operation, but the police were not in a hazardous operation, they were called just to monitor a demonstration, of which they didn't. And thirdly, if it's on public interest, then they will be required to use force. They have not demonstrated any of the above in their submissions. And therefore, Your Honor, I beg to call my co-counsel to proceed with the arguments of submission. I beg to take my seat.
Thank you, Counsel, for your most eloquent presentation.
Thank you.
Good afternoon, my ladies and my lords. My name is Masinde Nafula, and I'm going to be presenting on our second part of Limb 2, and I'll conclude with Limb 3, and finally, I'll put our prayers forth before this court. My lord, the failure of the state to conclude investigations was in violation of the Constitution and other international human rights law.
Direction from the bench, and finish up with the duty to investigate, begin with enforced disappearance.
Thank you, my lord. My lord, enforced disappearance of Mumbai by the Nadia police is in violation of the Constitution and other international human rights law. Article 2 of the Convention Against Enforced Disappearance, as well as Article 7 of the Rome Statute, have clearly laid out the elements of enforced disappearance as follows. Firstly, there has to be deprivation of the right to liberty of the subject. Secondly, there must be involvement of state agents, whether indirectly or by acquiescence. And lastly, there must be refusal to disclose the whereabouts of the subject, my lord and my ladies. As extracted from the facts together with the definition and elements of enforced disappearance, firstly, there was the deprivation of Mumbea's liberty. When you're reading the facts from paragraph 18 through to paragraph 20, it is demonstrated that Mumbea indeed made a decision to go and report to Hongo police station, and in paragraph 20, 2 witnesses come forth to indeed confirm that Mumbea was held with them briefly at Hongo police station before he was moved, my ladies and my lords. Secondly, there is the involvement of government officials, who in this case are the police at the Hongo police station. And lastly, the state has refused to disclose the fate of Mumbea and the whereabouts of Mumbea to the family. My lords and my ladies, the Human Rights Committee, in its communication 950/2000, stated that enforced disappearance in itself poses a threat to various human rights, namely the right to liberty as enshrined under Article 29 of the Constitution of Nadia and Article 9 of the ICCPR. Secondly, enforced disappearance poses a threat to the right to life as enshrined under Article 26 of the Constitution of Nadia and Article 6 of the ICCPR. And lastly, enforced disappearance poses a threat to the right not to be subjected to torture, cruel, inhuman, or degrading treatment, my lords and my ladies. The Human Rights Committee, in the case of San Juan Arivelo versus Colombia, held the state of Colombia liable for enforced disappearance and for violating the rights of life and the right to liberty and security of persons after the San Juan brothers disappeared after having been arrested by the Colombian police, my lords and my ladies. It is therefore our prayer that this court hold the state of Nadia responsible for the enforced disappearance of Mumbea, and failure to do so will provide a climate and will facilitate instances whereby the citizens of Nadia do disappear and no one is interested in...
Council, slow down.
Thank you for that, my lord. I apologize.
You're on the right track, though. Slow down.
Thank you, my lady. The state of Nadia does pray that this state, that this court hold the state of Nadia responsible for the enforced disappearance of Mumbea in order to prevent such instances in the future, my ladies and my lords.
You're leaving a key element, which I don't know how you're going to marry that with your submission, because isn't it that there was a call for him to come out of hiding?
Thank you for that question, my lady. The main reason why Mumbea went into hiding, my lady, is because immediately he released that video of Kilina shooting Tanjari, he began receiving death threats, my lady, from anonymous sources, my lady.
And then he was called out to come and give a statement as a witness.
Thank you, my lady. Indeed, Mumbea came forth to report a statement at Hongo police station, and my lady, it is from there on that we are unable to trace the whereabouts of Mumbea, my lady.
We are not communicating.
Yes,
that is okay, proceed on.
Thank you, my lady. Having submitted that, we the petitioners do seek that this court exercise its mandate under Article 23 of the Constitution of Nadia, together with Section 389 of the Criminal Procedure Code, to order the Inspector General of Police in Nadia to either produce Mumbea before this court to be charged or to be released if no charge is preferred against him.
Counsel, from a brief reading of the facts, wasn't the wife of Mumbea taken around the police station, shown that Mumbea is not being held there? What do you have to say about that?
Thank you for that question, my lord. It is the petitioner's submission that this was just stage management by the police in order to cover up the issue that they were holding Mumbea in custody at Hongo police station.
Counsel, what evidence do you have that Mumbea was present at that police station, yet there is no record in the occurrence book indicating that he was booked in?
Thank you for that question, my lord. 2 witnesses, my lord, in paragraph 20 have indeed come forth to confirm that Mumbea was held with them briefly at Hongo police station before he was moved.
Do you have sworn witness statements to that effect?
My lady, the petitioners currently do not have sworn statements.
You will want to submit it after court?
No, my lord. The petitioners currently do not have sworn statements. However, we do pray that this court consider the credibility and reliability of the statements of those two witnesses and not to dismiss them merely because, my lord, we have failed to adduce the sworn statements of the witnesses, my lord.
Okay.
My lord, having established that, I will move back to issue number 2, which is that the state's failure to conclude investigation was in violation of the Constitution and other international human rights law. My lord.
Question. How can the state be held responsible when there are no witnesses? Can the state now create the evidence just to show that they are complying with the obligation from the facts? What evidence have they failed to investigate?
Thank you for that question, my lord. The state, my lord, after having Mumbea was last seen in the custody of the police, and the state have not produced before this court any evidence to deny the fact that Mumbea was in their custody, my lord.
Their records don't support that assertion, so what else do you expect the state to produce? The state records, police records don't show that Mumbea was at the station, so what else is there for them to investigate?
My lord, it is our submission that the state, by failing to record Mumbea's threats in the state's in the police station's occurrence book, was in violation of the 5th schedule of the National Police Service Act, my lord, and they solely failed to record Mumbea's statements in the occurrence book with the intention, my lord. We, the petitioners, do suspect that the state has officers that are affiliated and are sympathetic to Kilina, and that's why.
Number one, it's an issue of evidence. What the state did or failed to do. Who has the legal burden of evidence?
Thank you, my lord. We, the petitioners, are the ones.
Legal burden.
Yes, my lord.
Show us the proof.
My lord. Thank you, my lord. My lord, we, the petitioners, do solely rely on the evidence that was presented by the two witnesses who were held together with Mumbea at Hongo Police Station.
That's only evidence.
Yes, my lord. My lord, I'll proceed with the second limb. Section 24 of the National Police Service Act.
Before you proceed, if the two witnesses are part and parcel of your evidence or what you rely on to make that assertion, do you mean that the police spokesman is a liar when he actually said that they have no record of Mumbea being in any police station? Mumbea was never in any police station. Mumbea never reported to any police station. No one knows where Mumbea is, number one. And number two, Mumbea having been in a habit of going into hiding, can this be one of those circumstances where he's in hiding? And you want this court to issue orders in vain?
Thank you for those questions, my lord. First and foremost, the police spokesman is a person that engages in public human relations, my lord. And secondly, the state of Nadia, my lord, the state of Nadia has been on the UN watch list for extrajudicial killings and for enforced disappearance, my lord.
What is the property value of that report?
My lord, it has been submitted by jurists from the Amnesty International, my lord.
What is the property value of Amnesty reports? Amnesty reports?
Thank you, my lord. We do submit that. First and foremost, my lord, that report was also reported by the United Nations, and the state of Nadia has ratified all... you
understand my question?
Yes, my lord.
Not what property value is.
Thank you, my lord.
What is property value?
My lord, property value is the relevance and the binding effect of that report before this court, my lord. My lord, therefore, the petitioners do submit that as much as this report is not binding on this court, my lord, that this court be guided, and we are also using this report for persuasive means before this court, my lord.
Okay, let me ask you. Do you want this court to disregard documentary evidence in terms of the OB?
Thank you very much, my lord, for that question. We do not plead that this court disregard the documentary evidence of the OB, my lord, but rather, my lord, to act in the favor of the petitioners and of the families that are related to the Mumbea, my lord, and in order to effect the right of Mumbea, my lord, we do pray that you hold...
Why shouldn't we consider OB? I'm not getting sufficient about that.
Yes, my lord. My Lord, the OB, we cannot rely on the police with regard to registering the threats of Mumbai in the station's occurrence book, my Lord. Because in the first place, Mumbai went to Hombo Police Station, a station that is far away from Nabi, for failure of encountering officers that were affiliated or sympathetic to Kilina, my Lord. This, my Lord, establishes an intention of the police to fail to record Mumbai in the occurrence book of the state in order to protect their own, my Lord.
Also, make your concluding statements.
My Lord, I would like to briefly submit on issue number 2. The state has failed in its national obligation under Section 24 of the National Police Service Act by failing to conduct investigation, and likewise, it is in violation of Article 2 of the ICCPR, which mandates the state to always protect the rights provided therein and to prepare effective redress in case of any human rights violations, my Lord. In the fact, my Lord, it is demonstrated that it is now a year after the killing of Tanjari and her 10-year-old brother, yet no conviction has been procured for what the state terms as lack of insufficient evidence. We, the petitioners, do submit before this court that the state indeed has primary or rather material evidence to convict this matter, basing on the fact that the ballistic examination of one of the bullets lodged in Tanjari's body matched that of the gun given to Kilina on that particular day, my lords and my ladies.
One final question. What is the balance between the respect for human rights, the state's argument for balancing security, the state's argument of maintaining security, and human rights, the human rights for your clients? What is the balance? What's the test that you want the court to adopt?
Thank you, my Lord, for that question. My Lord, the petitioners do submit that denying human rights, denying people their rights is equal to denying them their humanity. Therefore, the state, in a bid to ensure that they secure national security, should come up with legislation to ensure that as they effect the national security of the state, they do not infringe upon the rights of the citizens of Nadia, my Lord.
So that's the test.
What is the test?
My Lord, we do pray that this court applies the proportionality test, my Lord.
As defined by whom? Is there comparative jurisprudence?
No, my Lord, we do not have comparative jurisprudence, but we do pray that this court rely on the case of Ferdinand Waititu versus the Attorney General, in which it was held that the court, in determining proportionality, should give regard to the necessity and the justifiability of the force used by the police, my Lord.
So that's on a case-by-case basis?
No, my Lord, it is not on a case-by-case basis, my Lord. But we do pray that this court do consider putting human rights and national security on a scale in order to ensure that the two are balanced, my Lord.
Thank you, Council.
My Lord, 30 seconds to finish with our prayers.
Thank you very much. We will read your prayers in your written submissions.
Thank you, my Lord.
The first council for the respondents for the rest of the
Good afternoon, Your Honors. If it may please this court, I'm Quinta Chemotino, first counsel for the respondent. My co-counsel is Kipin Isidori. We will be responding to the issues brought forth by the petitioners, the first of which is whether the Nigerian state actors violated the Constitution and international human rights law in quelling the protests. The same shall be handled by my co-counsel. The second issue before this court, which we have subdivided into two, the first bit being whether there's excessive use of force leading to the death of Tanjari and her brother. The same shall equally be handled by my co-counsel. And the second limb of the same, which is on the failure of the state to conclude investigation, which I shall handle. And the third issue before this court is on the enforced disappearance of Mumbai and Milan, and whether the court can proceed to issue an order of habeas corpus in that regard. We intend to rely on the Constitution of Nadia, various statutes in Nadia, international treaties ratified by Nadia, and case law. We shall use 15 minutes each of the course time, and unless the bench directs otherwise, I beg to proceed to my submissions. Thank you, Your Honors. The respondents do not contest the jurisdiction of the court in this regard, as we are cognizant of Articles 23 and 165(3)(b) of the Constitution that gives the court jurisdiction to listen to the issues brought forth. Therefore, I would like to proceed to the third issue for determination before this court, on whether there was enforced disappearance of Mumbeya and Dylan, and whether the court can issue an order of habeas corpus for the production of Mumbeya before this court. Your Honours, counsel for the petitioners highlighted correctly, pursuant to Article 2 of the International Convention for the Protection of Persons Against Enforced Disappearance as, number 1, the elements being deprivation of liberty by the state or its actors, followed by refusal of the same and a concealment of the whereabouts of the individuals. Your Honor, it is the respondent's submission that in this regard, the same has not been met. Your Honor, as regards Mumbeya's case, it is a submission of the respondents pursuant to paragraph 19 of the fact sheet. In fact, the last sentence, which expressly states that the records at Hongo Police Station show no evidence of Mumbeya ever being booked there. Your Honor, the 5th schedule of the National Police Service Act, number 11A of 2011, expressly provides that in processes of arrest and detention, the officer shall enter particulars of the individual in a register. Your Honor, it is a submission of the respondent that there is no evidence of the same. Our records show no evidence of Mumbeya being booked there. Your Honor, further to that, pursuant to paragraph 18 of the fact sheet, in fact, the officer in the station informs Siki, Mumbeya's wife, that there was no records of the same in the occurrence book. She even proceeds to give Siki a tour of the holding cells. Your Honor, General Standing Orders 303 on the occurrence book provide that the occurrence book is a faithful and accurate record of all matters requiring the attention and investigation by the service. Therefore, if there was no mention of Mumbeya's allegations in the occurrence book, it simply follows he was not at Hongo Police Station to make that report.
Counsel, maybe a clarification. Is there a legal requirement that for one to file for or to make an application for a writ of habeas corpus, one of the requirements, a legal requirement, is that a record must be produced that this person was present at a police station through the occurrence book? Is there a specific section of the law you can pinpoint this or to say that it makes it mandatory? Or the 6th schedule only makes it a duty of the police to make sure that they record statements in the occurrence book? Which one of the two is it?
Thank you for
as well as you answer that, are those internal requirements of the police, or are they binding to the public?
Thank you for your question, Your Honor. In answering the first question put forth to me, I would like to rely on the case of Mariam Mohammed.
Before you go to the case, is there a specific provision of law which makes it an obligation or mandatory for a potential applicant to produce a record in the occurrence book if there is none at all? So you can't make an application if there is no mention of that occurrence book. Is there a specific section of the law?
Thank
Yes
you for your
or no?
question,
Is
Your
this a
Honor.
yes or no question?
No, there is no specific section of the law. However, Your Honor, an order for habeas corpus can only suffice if the subject of that particular order is in the custody of the respondents. Your Honor, the order of habeas corpus, as was defined in the case of Mariam Mohammed versus the Attorney General and 2 others, 2007 before the High Court, hence persuasive before this court, it was stated that it is an order requiring the person who has detained another to produce them before the court in order for the legality of their detention to be determined. Your Honor, the requirement is that the person must have detained the other. Your Honor, our submission is that Mumbeya was not in our custody. Therefore, even if the court were to go ahead and issue a particular order of habeas corpus, it would be in vain for the simple reason that he was not in our custody. Now, Your Honor, proof of this is regards the records at Hongo Police Station. The only way to actually ascertain that indeed Mumbeya was held at Hongo Police Station is through the records therein. Your Honor, if the records show no proof of the same, it simply follows that he was not in our custody.
Who makes entries in the occurrence book?
Thank you for your question, Your Honor. The police officers.
So the public have no access to the occurrence book, do they?
Thank you for your question, Your Honor. However, it is a requirement that when one goes to make a claim to the police station, they have their records to be entered there.
Can they force the police to write the occurrence book?
Thank you for your question, Your Honor. No, they cannot. However,
so it is an internal, as my colleague had asked you, so it is an internal matter and not a matter of the general public. The general public have no control.
Thank you for your question, Your Honor. However, pursuant to Article 244 of the Constitution, we have trained our police officer to the highest standard of professionalism. Your Honor, that is why I have relied on the 5th schedule. One of the aspects of professionalism is that they have to enter these records, which is why it is our submission that they indeed would have entered.
Counsel, will you still subscribe the doctrine or the notion of professionalism to the police officer who shot an unarmed woman?
Thank you for the question, Your Honor.
They are still trained by you, isn't it?
Indeed.
Yes.
Thank you for the question.
So that means if they can shoot an unarmed woman, they can also miss to write in the occurrence book.
Thank you for the question, Your Honor. However, in regards to that, that would be
that the state, like the states of Nigeria, to comply with its international obligations.
Thank you very much.
Thank you, Your Honors. Thank you for your time.
At this point,
wanasoma pia judgment
imagine hata mimi nasikia kitu mbaya sana.
Acha ijaje